Greetings to everyone attending this show from around the world. I'm Afnan Khan, a fifth year law student, and I will be your host for the 73rd episode of TLR Shows. TLR now is a niche mentoring and training entity with presence in India and the Middle East. TLR now works with its customers to enable transformation in their professional and personal lives. And TLR shows are TLR Now's attempt to bring to the forefront leaders and achievers to share their transformational journeys. In this episode, we will be in conversation with Pushkar Thakur, the managing partner at Corridor Legal, about data privacy and you, a wake-up call. This discussion will provide context to the viewer about the importance of their personal data, how it is used, and what the implications of current legislation are, in addition to the way forward in this regard. Pushkar Thakur, I give you the floor, and would you like to introduce yourself, sir?
Firstly, Afnan, you can just call me Pushkar. So,
Yes.
thanks to the TLR show, and thank you, Afnan, for taking out time for this. Whilst I won't want to harp too much on my antecedents, I'm currently managing Corrida Legal. So, we are a boutique law firm focusing on corporate laws, litigation, employment law, and data protection, and we are based out of Delhi and Mumbai. That said, data protection is something very close to my heart and should be to everyone alike, given the very personal nature of the law and the subject as such. So I think it's a great topic that we've picked up today, and let's see how it goes.
Look forward to it, sir. Sir, according to you, to start off the discussion, what do you think is personal data? How does it relate to a common man's data? How are they supposed to understand it?
Uh, I think great question to start with, Afnan. Whilst I do think that the general audience here knows what personal data is, in the in the most simplest and the most layman terms, it is any data which helps identify an individual or any set of data thereof. So, in the Indian parlance, there is an upcoming law, as we are aware. So, as per that law and even the existing rules on personal data protection, personal data is a data or a set of such data and includes inferred data as well. With regards to any characteristic attributes or traits of a person, which helps identify that particular natural person. So any natural person who can be identified through data, say a phone, an email ID, an alias, or any financial data, say a credit card information, is all covered under the ambit of personal data. And say coming to your second point, which is as to how it relates to a common man. Personal data is there everywhere with us. In fact, the most personal law that I can find today, despite there being 1,000 different acts in India itself, is personal data protection. So it is applicable on a day-to-day basis to us. So say our phones, our email IDs, any interactions that we have with any third party, be it government or non-government, there is an inflow and outflow of personal data out there. So that is something that revolves around the common man. To give you an instance, even a driving license has your personal data. So of course, where a common man stands, it's exactly in the middle of the entire personal data ecosystem.
Seems to be digital dust absolutely everywhere, sir, with regard to tracking a person's information.
See, it's everywhere and it's intimidating, but definitely I don't see there being requisite planning in a very kosher manner, to be fairly honest.
Hmm.
In fact, to put things in perspective, you as a law student, and of course in my fraternity as well, for all the qualified lawyers, everyone has a slight notion that personal data is basically any data that helps identify and relates to online data. Not really so. Personal data can be data in an offline manner also. So if there is a simple IGL gas connection that you have taken, and for that you have, say per se, given your personal data, so that aspect is also very well covered under the not only the definition but the regulatory regime which is proposed to be there under the Personal Data Protection Act.
So,
So
sir,
definitely,
yeah,
yeah.
yes, sir. Is there an existing law on personal data protection in India? Like, what extent is its applicability and stuff?
Okay. On a positive note, Afnan, yes, there has been an existing set of rules ever since 2011.
Hmm.
I'll just perhaps quickly give you a brief background of where the law stands. So there was a set of rules taken out in the year of 2011. So those were the Information Technology Reasonable Security Practice and Procedures on Sensitive Personal Data Information Rules 2011. That said, the biggest thing that this set of rules lacked was teeth. So there was
Hmm.
no reporting mechanism for a person, for a data subject whose data was infringed. The rule set of rules, of course, provided for audits which were never conducted by the government.
Hmm.
So quite toothless, but definitely there were a set of rules, and of course after that the whole aspect of privacy vis-a-vis Aadhaar was challenged in the Puttaswamy judgment before the courts, and of course in that nine bench judgment it was held that the right to information privacy is a fundamental right, and post which all this Sri Krishna committee was formed, and the personal data bill, the first iteration was rolled out in 2018, and that further saw a revision in 2019, and I believe on December 10th or something, our minister, they referred the same to the joint parliamentary committee. But that said, not only today, not 2018, not 2019, ever since the advent of WhatsApps and
Hmm.
signals, the ambit of personal data has been there as long as 10 years back, since 2011.
So, Pushkar, according to you, what is the upcoming law on personal data protection like? It's inspired from the GDPR, is what I think is true. And what are the changes that have come up in this compared to what it was before?
Okay, so Afnan, that's a very good question, I must say. So to put things on a very simpler perspective, say in colleges we used to be given projects to make, which we never wanted to make, and we would take some seniors project and then, of course, improvise on it, add some few critical points to make sure that there was some sweat of the brow from my side. I think personal data is somewhat a sort of a baby, but has from the erstwhile laws like GDPR,
Hmm.
so has many things which flow from these international legislations, but there are of course certain things which the legislature has put in the law which are completely nascent and specific to India, like say data localization requirements, etc.
Hmm.
So similar yet different in multiple regards.
So, now you mentioned about data localization. What are the types of data as per this new PDP bill, and who are the major stakeholders of the bill, and the entities that are regulated by the bill? It's a threefold question. I hope that's you know.
Okay, so not a concern. See, we have to firstly understand why the law. So the Personal Data Protection Act, the very preamble states that it's for the protection of the privacy rights of individuals and to create a relationship of trust between the data subject and the data controller, which is called the data fiduciary in India. So the whole purpose being this, and of course providing the aspect of a data protection authority, etc. So definitely, and the stake. Talking about the stakeholders, the biggest stakeholder is the individual person whose personal
Hmm.
data is involved. Then there are non-state players like private entities. Now these private entities kick in a big manner because, of course, there is the whole aspect of metadata and profiling, etc.
Hmm.
And of course, data has been said in reports that data is the new oil. So keeping it on that balance, of course, non-governmental players are there, and then of course there is government, which is in fact the biggest custodian of personal data in India, and in fact everywhere else internationally. So yes, the biggest stakeholders are the individuals, the non-government entities, and the government entities. Yeah. Anything further on this question, Afnan?
I wanted to know about data localization actually, sir. What
Yeah.
exactly is data localization about?
Okay. So data localization is a fairly simple concept. Uh, in India, the scope of the upcoming law, which is the Personal Data Protection Act, which has extremely high legal ramifications, I must say.
Hmm.
It covers any data that is processed in India. Now, this will also include, and also a point to be noted here is that the definition of processing even includes deletion. So, if any data is being procured from outside, even if it is deleted, the law will apply. So, flowing from this, The aspect of localization simply is that whilst the data may be transferred outside the territorial jurisdiction of our country and can definitely flow outside the country, a copy of the same will have to be stored in the servers in India. So this is a far cry from the GDPR, and in fact, quite unique of us to impose this requirement, and definitely becomes an issue when it comes to processing of data of international persons, because eventually, because of what the data localization requirements are, that if say hypothetically I'm a GCC or a captive unit of say of an American entity, and say there are people belonging to states of Wisconsin and Tennessee, their data, sensitive data, in fact, will also have to be stored in India, whilst it can be transferred. So it has, of course, it has a trickling effect on all the corporates, because a lot of corporates are keeping their KPOs, LPOs here, and there is a lot of data that is resting, and which will eventually just mean that their business will get killed, because I personally don't think, and there are reports as well which suggest that people are not very happy with parting their data, especially in the Western countries, given the higher amount of sensitization. So that's what it is. And to put things into a legislative perspective, Afnan, this was something which came up in the very first iteration of the bill. So in the 2018 version of the Personal Data Protection Bill, data localization requirements were there not only for sensitive personal data, for personal data as well. So I'll just quickly describe the different types of personal data. Personal data is in India, of course, personal data means any data or set of data which has any, which can basically help identify you and is with regards to any characteristic traits, attributes. There is a further classification of personal data in India, which is sensitive personal data. Now, sensitive personal data, in a very simple term, is just the higher level of privacy which is there with regards to the nature of data that is classified as such. So your biometrics, your health data, your financial data, your demographic data, your official identifiers, all these across a higher threshold are covered under sensitive personal data. There is a further classification of personal data, which is critical personal data, but that is yet to be defined by the government. So, given these three definitions that are there in the whole regime, Afnan, initially in 2018, the version that came up, it required data localization also of the personal data along with the sensitive personal data, but luckily they have taken that away. So, in the latest iteration of the bill, which is currently pending before the Joint Parliamentary Committee headed by Meenakshi Lekhi, uh, the aspect of localization of personal data has been taken off, but sensitive personal data is still there. So any data, sensitive personal data being processed in India, albeit of a foreigner, will have to be stored in India. So this becomes a trickling concern for the larger corporates, especially coupled with the fact that any sensitive personal data can be taken only upon explicit consent to the data subject. So not only do I have to make sure that the consent taken from the data subject is free, informed, clear, and specific, we also have to tell the person about the potential harm that can arise out of sharing of such sensitive personal data. The whole aspect of the notice has to be extremely clear, and we also have to give options to the data subject to separately consent to different types of sensitive personal data. Now, putting all this legal jargon into the practical world, say if I'm an organization like a Fair Portal, or say a Thomas Cook or a IATA, then I'm actually required to go to all these guys in US, Australia, EU, and where not, and take their explicit consent before I can process the data in India, which does not only become a does not only become a hindrance, it makes it an impossibility to conduct business in India with respect to sensitive personal data. So, and in
Great.
fact, this is also one of the teething issues which are under discussions, and I believe some, as per news reports, some around 180 amendments were proposed by the committee, and in fact, the revised version of the bill can be tabled anytime before the parliament now.
With regard to what you just spoke about, we all understand that the personal data bill is currently under discussion before the parliamentary
Yeah.
committee. Can you highlight the key issues which are under discussion, Pushkar?
See, many issues, Afnan, but I won't like to harp too much. Let's take the intended audience in place. I think it's all the folks from LinkedIn and all the individuals. So let's keep it fairly simple. Two aspects. The one which we have already, I think, discussed and dealt upon in detail, which is the aspect of data localization. So, if I have to collect any personal data in terms of the latest laws which are to come into force, I need to give that person a notice. Now, that notice also has specific requirements. And after that notice, I have to take the consent.
Hmm,
For sensitive personal data, there is an aspect of explicit consent also required. Now,
hmm,
keeping all those things into mind, it will become a biggest downer for international corporates for to do business in India. And please note that definitely personal data is definitely gaining mileage. How we knew PD 10 years back is definitely not how it stands today. In fact, we can all witness that from the privacy policy of, oh, so sorry, terms and conditions of WhatsApp. So
definitely.
all that said, of course, yeah. So of course, people are getting more serious about it, and this is a big hindrance. So somewhere it shows that there is a thought of making the law simpler, but it is somewhere hindering felicitation, especially with respect to one of the key stakeholders, which are the private players.
Hmm,
So something that needs to be looked into here. And perhaps, Afnan, in fact, given we work with clients on personal data, one thing, it's a very simple solution somewhere, perhaps. In India, the law says that any data that is processed in India will be covered under personal data protection law.
yeah.
Then you have a requirement of not transferring sensitive personal data outside, which somewhere to an extent I can fathom given if the data of a national, say I, Pushkar Thakur, or you, Afnan Khan, want to give his, if your sensitive personal data is being stored by the state, fair enough. So what can simply be done in is that in the whole section in the section of the law regarding
Hmm,
localization requirement, they can simply put that this localization requirement for sensitive personal data storage in India and non-transfer of critical data, since critical data just cannot be transferred unless it's for an emergency service situation,
hmm,
which in fact the government thinks will not negatively hamper the personal data.
yeah.
So if so that said, we can just add a simple proviso that this section will not be applicable to personal data of foreigners. That will just take care of all the thoughts, all the situations. All the international MNCs will be happy because they will then not have to get explicit consent from every Tim Jones and Harry Smith from Adelaide and Brisbane. So it will just make things simpler for the entire economy, and in the same vein, also help the government keep the data intact, what it needs to say for perhaps welfare subsidiary or defense services. And so this is the first big problem of data localization. And other than this, of course, there is the whole aspect of state responsibility.
Hmm,
So, Afnan, I must say, given the very limited knowledge I have of the international laws on data protection, the country, the state actually acts as a model for the rest of the players with respect to data protection and the say the controls, the compliances that they put in. However, in India, uh, as per the extant laws that are there, of course, subject to revision basis the inputs of the Joint Parliamentary Committee, any services or benefits being provided by any agency of the state will be outside the purview of the for will be outside the purview of consent. So
hmm,
what this means is that if you are taking any benefit or a subsidy, say a provident fund or say even a gas subsidy, the government will not be asking you for consent.
hmm,
And that's a big question because of the fact that government is not a small player here. I understand, and of course, the market also understands that it is not always possible to be the benchmarking agent with regards to every law. But what has to be understood here is that government is one of the biggest holders of, is the one of the biggest data fiduciaries. The government has all our data when it comes to say provident fund, gratuity, labor welfare fund, employee state insurance. with respect services, with respect to employment, and even for general things like your driving license also has your personal data. Your property registration documents have your personal data. So government is a big player, and that said, in addition to the aspect that benefits and services will not come under the purview of consent, there is also another piece in the law, which I believe is Section 35 of the law, which actually gives the government a clear, the central government a clear right to exempt any agency from the operation of the law. So government agency. So this is somewhat blows hot and cold because somewhere the whole aspect of Rex non potest picare comes into the picture. So and that said, this is something that needs to be looked into because in fact this somewhat looks like a situation where the government is taking data and is in fact regulating itself. And to put things deeper into the perspective, yes, there are safeguards to the government when it comes to any agency giving any benefits or services, and they are definitely outside the scope of consent. There are laws. It is also to be noted that the government has very wide powers to operate under the law as well. The primary authority that is to be formed under the Personal Data Protection Act, which is the Data Protection Authority, is in fact to be formed by the central government. So what we see is that the central government is one of the biggest custodian of the personal data, is somewhere exempt, has power to further exempt its limbs, and in fact further has the power to establish the authority itself for administering of personal data. Now, another thing perhaps that can be added here is that any if you are aggrieved by any decision of the data protection authority, you can only go to the appellate tribunal as a first step, at least.
Yes, I remember
So
coming
it
across
somewhere
this. Yes.
shows that,
Yeah. Yeah.
yeah. So eventually you are stuck with the government if you
Exactly.
are in this ambit. So in fact, so there can be perhaps a line of judiciary in the between to take care of all these things, especially with respect to exemptions. But yes, definitely something needs to be done with respect to accountability of the government. So these are the two teething issues, and just one thing on the intervention. So one aspect that has already been there, which is teething our economy, is that there are laws which already give the government the right to intercept our communications when it is in the interest of sovereignty or national integrity. So that I believe is, I think, Section 5.2 of the Telegraph Act, which gives the
Yeah.
government the right to
Telegraph Act. Yeah.
intercept telephone communications, and Section 69 of the Information Technology Act, which gives the government the right to not only inspect but also monitor computer resources. So that said, these two aspects are already covered. So somewhere these laws will also be having an overarching effect on the personal data aspect, and we really will never know what personal data the government has about us, uh, uh, because of course there will be no consent, and the government has must say wide plenary powers with respect to monitoring of your conversations, both on computer resources as well as on telephones. So, somewhat of a concern, but definitely I'm sure that the parliamentary committee is looking into it. And with respect to, of course, all the interests of the stakeholders and how this government is pro entrepreneurship and pro, of course, movement to a higher footing. I think things will be moving in a positive direction.
So quite a few machineries in this bill are very discretionary in nature, and we've got to deal with them. Is what you're summing up to say? Is that so?
Unfortunately, yes.
Yes.
To put things in perspective, the data protection. Okay, so I'm an organization. So what has to be seen here is that in addition to a data fiduciary, the government, again the central government, can prescribe certain organizations as significant data fiduciaries.
Hmm.
Now the discretion to classify this lies with the government. Now, if a
Exactly.
significant data fiduciary has allegedly not conducted either of these three things, which is either a data audit or a data protection impact assessment, which is when the significant data fiduciary takes up any processing of a large nature or involving a new technology, or simply your basic requirements, then it can be fined 5 crores or 2% of the worldwide turnover, which is an extremely high amount.
It
But
is.
again, the decision to adjudicate this, and perhaps unfortunately that's the term, lies with the central government again, and the appellate authority again falls under that ambit. So it is somewhere there that the person prescribing the law, making you stand by it and telling you you're wrong, and in fact deciding on your case is the government itself. So somewhere we can of course hope that judicial intervention also comes up, like in many other laws.
So, as you yourself said, in fact, keeping in mind the ongoing discussion regarding the involvement of the government, can you let us know how the bill stands with this respect? What are your views on the access the government will be having as per the extent bill?
See, of course, government has all the access. Okay,
So
so
that only
let's
thing.
start with that notion first.
Hmm,
Let's start with that notion first, because see, breaking things down, what is my personal data? My name, my alias, my email ID, my financial data. Now, if I go for a provident fund registration, which is compulsory, of course, if I'm an employee,
hmm,
then all these details have to be enclosed in Form 11 and 13 before the authorities. Those lie with the authorities. Now, coming back to the very first topic that we discussed, personal data also includes data that is there in an offline manner.
hmm.
So, in fact, government has all our personal data. So, and in fact, this becomes a concern because the level of security safeguards that are there, yeah, the government agencies can also be exempted from abiding with that. So there is no surety that my data will stay safe,
Hmm.
and I believe that's the biggest concern, especially given the growing, say, what do you say, growing interest and awareness towards the whole aspect of personal data.
So, what do you think are the legal ramifications of breaching the upcoming law on this on personal data protection?
A good question, Afnan. Whilst they are high, I do personally think that they are very much required.
Hmm,
We've had the set of rules from 2011 itself, the ITRS SPDI rules, which I informed you about initially. But they are somewhat toothless, provides the government the right to do audits and checks, which have never happened. Does not have any data subject rights. So, say rules are there, but your rights get infringed and you don't know what to do. Of course, you
hmm.
can proceed, but you need to have a recourse as well, right? So that
Yes.
said, yes, legal ramifications are high. And talking about the figures, it is definitely graded penalty.
Hmm,
So, say you breach any requirement of a data protection impact assessment, or say appointment of a data protection officer, uh, and simpler things like that, and then that entails a fine of up to 5 crores or 2% of the worldwide turnover. Now,
hmm.
it's not the profit, it's not and country specific profit, it's the worldwide turnover, which can even 2% of the worldwide turnover for all intents and purposes can be even more than the profit that the company rakes in a financial year.
Exactly.
So even a F500, a Fortune 500, can be making less than 2% of its total revenue as profit, and
Hmm,
that sort of an organization, as being extremely large, will be under a fix if such sort of a ramifications is put forth. And to put things into perspective, given the graded penalty nature, say if you breach requirements with respect to children, or if you breach the simple notice requirements as are enshrined under chapter 2, you will actually be required to pay amounts up to 15 crores or 4% of the worldwide turnover. So, which I believe is extremely tough, and somewhere not only dissuades but pushes back on the whole aspect of ease of doing business in India.
hmm. Absolutely. Uh, this is actually the next question is actually a doubt I had from quite a long time, I think, since I'd been following data protection in my own course. Is the Aadhaar Act also
Yeah.
under this bill? Aadhaar data and the Aadhaar Act. Does it come under personal data?
See, UIDI states that Aadhaar is it's clearly, but otherwise, but on the whole aspect of an Aadhaar card. But what Aadhaar
Hmm,
contains is your Aadhaar number. So your
hmm,
Aadhaar number is sensitive personal data because
hmm,
of the fact that it's an official identifier.
hmm,
Now, coming back to the law, sensitive personal data in its very definition includes official identifiers. Official identifiers are nothing but codes and numbers given to individuals as part of their identity.
hmm,
So an Aadhaar number is definitely an official identifier, and is very well your sensitive personal data. In fact, the name, the lias, etc., mentioned in your Aadhaar are also personal data. So personal data, Aadhaar is a mix of personal data and sensitive personal data. Uh, but that said, Aadhaar is an additional piece of concern for the Indian government. Uh,
Hmm.
Aadhaar, although the act is very well drafted, in fact, it was questioned as well in the Swami judgment, wherein
Hmm.
Section 57 was struck down, which allowed private entities to take Aadhaar for verification purposes.
Hmm.
But that said, the whole aspect of enforcement of the law comes into picture again, and say to connect the whole thought process with this particular situation only. So uh, the whole aspect of whether private entities can take Aadhaar for your ID purposes was challenged before the Apex court, and in a nine judge judgment, it was basically pronounced that information privacy is a fundamental right.
Hmm.
Whatever the section 57 of the Aadhaar Act 2016 was struck down to the extent that it allowed private players to take your Aadhaar. And furthermore, there are a set of rules called prevention of money laundering rules, which are required to be
Hmm.
abided by for any KYC with any account holder. So earlier they used to have Aadhaar, but post this judgment, the whole aspect of Aadhaar was taken off, and it was made clear that no private entity can insist for Aadhaar unless the client insists to provide it. And
Hmm.
if, as a private entity, you are asking for Aadhaar, then you have to make sure that your client redacts or blacks out that particular Aadhaar number.
Hmm.
But in practical scenario, in practical parlances, even if you go to get your mobile SIM, they
Hmm.
ask you for your Aadhaar card. Even
Exactly.
if you go to get your car insurance done, they ask you for your Aadhaar card, which is not clearly but patently illegal in India now. So leave alone sensitization to individuals, the adequate sensitization and bonhomie has to be done with corporates as well as to how to ensure Aadhaar collection, because the moment the mechanism wakes up, they all will be in a soup. So Aadhaar
Hmm.
is definitely personal data, and very strict legal ramifications. Again, provides for penalties and has very strict requirements, in fact, for storage of Aadhaar. So, Afnan, if you allow me, I can just I quickly spell out some requirements which are there for corporates taking Aadhaar.
Definitely,
So,
sir.
like I said, Aadhaar cannot be asked for by corporates for the
Hmm.
purpose of ID, but they're still asking for it, which has to be fixed. But say you have Aadhaar in your ecosystem, in your database, be it for provident fund purposes, or the fact that you have already taken Aadhaar from a lot of people who you are having a account based relationship, like a bank or a merchant banker or any portfolio manager for that matter. So the whole aspect is that for taking this personal data, for keeping this Aadhaar also, companies are required to have very high level of security internally, which is called an Aadhaar data vault, which again is something amiss in the corporate regime. Of course, the top corporates are cognizant on it, taking action and making sure that they have the requisite HSM keys and the Aadhaar data
Hmm.
vault, everything in place. There is secured access to Aadhaar. But I don't see general corporates and even smaller NBFC startups which are into, say, micro lending or, in fact, even small to mid-term loans. They are definitely not keeping in regards to this. And somewhere also stems down to the fact that the government is, or perhaps the machinery is not jumping in enough on enforcing this particular piece of law.
Hmm.
So companies also have to abide by very strict requirements, but provided, of course, that there is machinery to kick in and people are somewhat deterred from taking any violations. So that has to be done. So Aadhaar sensitization as such is not only on the individual level; it's on the organizational level as well. For an individual, don't give Aadhaar to a private player unless it's a government subsidy or a benefit,
Hmm.
unless it's a targeted delivery of services to you as per the Aadhaar Act, you are not supposed to give Aadhaar. And if you do, black out your Aadhaar number. And for corporates, they have to make sure that if they have any footprint of Aadhaar in their ecosystem, they have to have the Aadhaar data vaults, they have to have the HSM keys, and there are specific circulars and guidelines issued by Honorable UIDAI in this regard, and they will have to assure strict abidance. So it's a two-edged sword, but definitely cutting both the stakeholders. But both of them have to be very specific about this particular piece.
So we seem to be requiring a lot of awareness in this regard as a nation, the people of the country. What do you feel as a citizen from an individual perspective? What is to be kept in mind whilst sharing Aadhaar data with, let's say, another organization which could track it?
Say no to private companies. Say no, you will not give the Aadhaar.
Hmm,
For public, definitely give the Aadhaar because it's somewhere required, and that's the whole purpose of
hmm,
Aadhaar. It's a social security. Yeah, and but for private, don't give Aadhaar. Whoever has your Aadhaar, please make sure that they are redacting it. Otherwise, otherwise they will be in violation, and you will be losing out your personal data again,
hmm.
and that's a sensitive personal data. So that's something that I can just think at the top of my mind what a person has to do. And of course, a corporate while collecting Aadhaar has to ensure that its clients black out the Aadhaar and be
Yeah.
very specific about this particular requirement because, of course, as things go, as organizations grow bigger, the footprint of personal data keeps increasing and never decreases. So that's my 2 cents.
So we've seen as time has passed in the last 2 3 years or so, we've got a lot of international influence when it comes to the personal data protection bill. How do you feel the GDPR influences the collection and the processing of personal data in India? And what types of organizations do you think are required to abide by GDPR requirements?
Awesome question, Afnan. GDPR covers the processing of any EU data subject
Hmm,
or a data principal. Uh, so that said, let's have a clear bifurcation.
hmm,
Any data that is processed in India will be covered by the upcoming Personal Data Protection Act,
hmm,
and the European General Data Protection Regulations will only apply to the processing of any EU subject,
hmm,
processing of any data of any EU subject in India. So corporates who are having anything to do, even with a phone number or an email ID of a person whose payroll data, say, perhaps has to be deleted, given
hmm,
we also serve as captive units and back end offices for a lot of global corporates. So even if the data is being
hmm,
procured in India for the purpose of deletion, they will have to ensure that they are compliant with GDPR. Now, how to do that?
hmm,
It's fairly simple, provided it's done in a very kosher and in a very specific manner. The first step is, of course, to check where all the personal data is resting in your organization, where all it has already seeped in, and where all it needs to be covered. Once you have, of course, tested the resting of the personal data, you can put in the adequate controls which are required under the GDPR, which is strict access, etc., etc. And other than that, post that, once all these things are in place to facilitate any movement of personal data, you will have to have the standard contractual clauses duly executed with the foreign party, which is providing you that EU specific personal data. And even after that, you have to maintain something, although GDPR is not given, of course, we dealt on Indian laws, GDPR is not our bread and butter, but
it isn't.
there is a certain thing called records of processing as per article, I think Article 30 of GDPR,
Hmm,
which requires you to keep clear, specific, informed records of processing. So these are the smaller bits that have to be taken into consideration if you are processing any of the EU related data. If
hmm.
no EU, be it an American or be it any say a Bahrain specific data, no frets. Just make sure that you are abiding by your own personal data requirements, and that's perhaps it.
So now bring it back to the Indian context. What are the key GDPR based requirements you feel are applicable in India, not other countries as such?
Uh, what GDPR based requirements are applicable in India?
In India, yes.
You have to keep records of processing. You have to keep the standard
Hmm,
contractual clauses. These two things have to be there, strict to sensu. So you do that and make sure that, of course, at the back end you have the things in place. Also, one thing which is quite important, given okay, so the GDPR also has very high legal ramifications, as you are aware.
hmm,
Again, the
hmm.
4%
Yes.
turnover and goes into millions. So that
Hmm,
said, perhaps what has to also be seen is the aspect of breach notification procedure, because
hmm,
GDPR as it provides a very strict time frame for breach notification to the authority. that has to be
Hmm.
followed in India as well, given that it's processing the EU data. So my only 2 cents is that have the records of processing in place, have the standard
Hmm.
contractual clauses, of course, executed, and sensitize your staff on the breach notification procedure that is there under GDPR, because they are legally bound to abide by it. And it's 72 hours. So the time
Hmm.
frame is actually quite strict, and this is something to be jumped into and delved into immediately once the organization knows about the particular violation.
So, Pushkar, we've discussed a lot about the different kinds of data and what the implications of these legislations are on that data. We've not discussed one yet, which is actually really important, is I think what it is in the Indian context as well. What do you think is the take of the new personal data protection bill on anonymous data?
Okay, so luckily something that we can raise our hands and say that it's all good.
Exactly.
Anonymous data, yeah. So coming to the definition first, anonymous data flows from the process of anonymization. Anonymization is nothing but irreversible process of changing the personal data to such a data that it does not help identify the particular individual to whom the personal data belongs.
Hmm.
Now, the law says that this personal data definition does not cover anonymized data. Whilst it covers
Hmm.
inferred data, say two
Hmm.
things, your email ID and your salary bracket can help identify you, so that will be
Hmm.
covered. But anonymous data is as such not covered under the data protection regulations. But again, an elephant in the room, we don't know what the government may do with it, what are the ramifications that may come out of it. So that is something only time can tell to us, Afnan.
So, Pushkar, according to you, how is a person getting an advantage in controlling the consent for the data which he or she gives to a data fiduciary or to data processors in the country?
Okay, so Afnan, definitely advantages, and uh, and that's somewhere also the whole thought process that the individual firstly needs to understand. Because today, if I ask you honestly, if I had a landlord, I would ask him that, hey, give me your Aadhaar. He'll drop it at the drop of a hat
Hmm.
and tell me that, okay, facilitate this. So, of course, sensitization needs to be there, but a data subject has certain rights now, which were not there with that person earlier. So,
Hmm.
the very first, there are certain rights which I'll just point out quickly, given we are short of time. The first one is, of course, right to confirmation. That so this is the particular right that you have the right to request any data fiduciaries slash data controller, which is basically any party which controls your data and decides what to do with it. You can ask that person that, hey, is my personal data with you? So get a confirmation. Other than that, you have a right to access as well. You can fairly access your personal data that is there. So you take care of all of that bits. And so right to confirmation, you have a right to access. Then you have a right to erasure. So right
Hmm.
to erasure is simply that if any of your personal data goes redundant and becomes obsolete, you have the right to get it erased from the records of the data fiduciary. Coming from the right to erasure is the simple right to be forgotten. You want to be forgotten by the corporate. Finally and luckily, you will be forgotten
Hmm.
as per the extant laws, which of course might get modified based on the JPC's report.
Hmm.
So currently, where we stand, this is how the whole ecosystem stands.
So, Pushkar,
And
if you had
just
to
one
sum
thing
up,
on that,
yeah, yeah.
Afnan, my apologies. Just one thing on that. There is also an aspect of data portability, which I find a very good
Hmm.
concept. So data portability basically means that, hey, if I'm say a multinational, I'm operating in India, I'm processing your data, and I've taken your personal data, and it's in a highly hodgepodge manner. So you have the right to data portability, which means that you have the right to ask me for your personal data, and I am legally bound and required to give you that personal data in a structured manner, in a generally used manner, and in a machine readable format. So that
Hmm.
is my obligation under law to give that data to you. So you have the right to port the data any day you want. So that is a strong recourse. So right to confirmation, right to access, right to erasure, right to be forgotten, and of course right to data portability are the, I think, the 4 5 rights that we have under the proposed law.
So, Pushkar, if you had to sum up the benefits of this legislation that we have in front of us, how would you do so? Is it beneficial to corporates, and in so what manner? And is it beneficial to citizens as well? And if so, in what manner?
See, definitely beneficial to citizens because it is finally giving them some rights, right?
Hmm,
But there is a teething issue which I will discuss towards the end. So, given I do see it as a big downer of now, and
hmm,
I have been a part of representations made to the ministry through ASIFMA, through different organizations
hmm,
as well. And no one seems to be harping on this, I believe, because they are not concerned commercially into this particular piece. But
hmm,
it's a downer for sure. So, on the very first aspect, yes, it's a great thing for individuals. They now know where their data will rest.
hmm,
So where their data will lie, they have all the rights that I just told you. So to put things into perspective, the previous law said that you will be informed about the parties who the data will be shared with.
hmm,
So a food eating website, okay, or an e-commerce venture will just tell you in its privacy policy that it's going to share its data with its affiliates. But
hmm.
what would actually happen is that you order a burger at 11:30 p.m. at night, you log into your social media account, and you see
Hmm.
a burger ad, and you are
Exactly.
miffed
Yeah.
and pissed as to how does this person know that I just ate a burger?
Hmm,
Yeah. So, given all of that, definitely, so that aspect will be taken care of because now under the new law, data fiduciary is required to cull out specifically the entities with whom the data will be shared. They will also be bound to maintain the same level of data protection. Further, there is a very small section, section 10, I believe, of the new Personal Data Protection Act. So that says that the data fiduciary will be responsible finally for any data that is processed on its behalf. So finally, we have some obligation. So unlike earlier instances where I could just pass off my data in a bulk manner, say that you take my personal data and go do some profiling with it. Now I'm under strict legal requirements to ensure that the specific names of the parties, etc., of course, portrayed to the data subject and informed specifically, and this has to form a part of the notice, must I say, under
hmm,
Section 7 1 of the Act. So that said, yes, that aspect has been taken care of, but there is again that very underlying issue which I perhaps would not want to delve into too much, but it is something that just is a downer in the whole aspect. Is what about the personal data that is already there in the public domain?
exactly.
What about the personal data that is already there? And won't take a rocket scientist to understand that tomorrow, today you say that Pushkar, find me Mr. X Godinho's details and leave alone his details. A normal person, leave alone a legal researcher, can find out the name of that person, his director identification number, the number of corporates he's director in, his personal details, his property details. The Delhi online registration system information system is there, say for the state of Delhi, where you can see any property registration details. So all that personal data is already there in the public domain. So how do we curb that back? So
Hmm,
somewhere I think that okay, so to put things into perspective, we are making a law on drug control, but the drugs are already out there. So something that to be looked into and something to be. So what about taking your personal data back? So perhaps moving a couple of steps back and trying to take into concern this particular piece and trying to get all your personal data back, and then putting in a machinery which is strict and making sure that it gives the relaxation and the peace of mind to international corporates, given the whole aspect of ease of doing business in India. Foreign people taken out of the aspect of data localization apropos sensitive personal data. So that I think needs to be done on a more stricter manner than it is being done now. Because today, where I see my personal data is already there in the public domain. So what am I protecting here?
So, you are of the opinion that there is machinery in place, but there is already data out there. So we need to find a way to curb spread of that data. Is that what you're saying, Pushkar?
Yeah, it is. Yeah, basically, see, they are trying to put in a machinery for ensuring that the corporates do not do X and Y with the personal data that they take. But what about the personal data that they already have?
Hmm,
That has not been taken into question.
sure.
Is there, see, a data protection impact assessment is only for significant data fiduciaries, but unfortunately does not cover the very simple, simple data fiduciaries who are there. What about a smaller corporate like, say, your travel agent who has all your personal data? How is that going to be taken back? So
Hmm,
before getting my before regulating my cattle, I would rather get it back in my stable and then regulate it, is my thought process.
Pushkar, this bill that we have that's going to be made into an act soon, this has certain other ancillary measures through which it operates. Like you've stated yourself, Section 5, Subsection 2 of the Telegraph Act, and certain other
Yeah,
provisions and other legislations. Do you believe
yeah.
that these provisions also need to be amended in order to make this bill more citizen friendly, so to speak?
Adnan, they need to be amended in order to not make them citizen unfriendly. Yeah, let's keep it like that.
Fair enough.
So
Yeah.
I don't want a situation where I'm talking to my beloved and there are instances where my personal data is being taken on the,
Hmm.
because see there are of course SOPs issued with respect to Telegraph Act. There are SOP specific ones issued. But that said, see, if you keep the ambit so wide as in the interest of sovereignty and integrity of the country,
Hmm.
and
Hmm.
especially whilst there are SOPs for the Telegraph Act 1885, which is again a 135-year-old law, or dare I say 136.2, what about the Information Technology Act? Where are the SOPs for that? And are you going to amend those SOPs apropos of the Personal Data Protection Act? They should be done. Otherwise, the law will stop to meet its purpose as well, and eventually so, yeah.
So, Pushkar, I've come to the end of my list of questions, and this offers, I think, a very important perspective to an Indian citizen because, frankly, I did not have half of an idea of what you just spoke about today. Despite having researched extensively on this in my third and fourth year, I've come across a lot of new perspective today, and I think all of us require that to all the viewers. And this is from the both of us. We thank you for logging into our show today, and we're grateful that we got to have this discussion because, as stated, we need a lot of perspective in this regard as a nation, as an individual citizen. And we have a lot of more exciting shows lined up for you in the months to come. Thank you, Pushkar. This has been extremely informative for me, I'm sure, and for everybody watching. And to everybody who's watching again, we thank you for your support and we wish to stay connected with you. Please follow us on LinkedIn and on Twitter, Facebook, and YouTube. And we have an Instagram handle as well that you could look at. You could also reach out to us on reach@tlrnow.com. And it's been a pleasure being your host for this episode. And I hope everyone stays safe and, in fact, more importantly, stay secure. Goodbye.
Thanks, Afnan. Thanks, Steve.
Take care.